అగ్రవర్గాల పేదలకు రిజర్వేషన్ పై సుప్రీంకోర్టు కీలక తీర్పునిచ్చింది. ఈడబ్ల్యూఎస్ రిజర్వేషన్లను రాజ్యాంగ ధర్మాసనం సమర్థించింది. వర్గాల్లోకి పేదలకు 10% రిజర్వేషన్లు కల్పించడంపై దాఖలైన పిటిషన్లను విచారించిన సుప్రీంకోర్టు ధర్మాసనం ఇవాళ తుది తీర్పునిచ్చింది. అగ్రవర్ణాల పేదలకు రిజర్వేషన్లపై సుప్రీంకోర్టు ధర్మాసనం కీలక తీర్పునిచ్చింది. ఈడబ్ల్యూఎస్ రిజర్వేషన్లను రాజ్యాంగ ధర్మాసనం సమర్థించింది. అగ్రవర్గాల్లోకి పేదలకు 10% రిజర్వేషన్లను కల్పించడంపై దాఖలైన పిటిషన్లను విచారించిన సుప్రీంకోర్టు ధర్మాసనం ఇవాళ తుది తీర్పునిచ్చింది.
That ceiling limit itself is not inflexible and in any case applies only to the reservations envisaged by Articles 15.4, 15.5 and 16.4 of the Constitution of India. Not much of the contentions have been urged in relation to the impact of the amendment in question on admissions to private unaided institutions. However, it could at once be clarified that what has been observed here and above in relation to the principal part of challenge to the amendment in question, read with the decision of this court in Pramati Trust, the answer to the issue framed in that regard would also be against the challenge. Accordingly, and in view of the above, the answers to the issues formulated in these matters are as follows. 1. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions, including reservation, based on economic criteria. 2. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions in relation to the admission to private unaided institutions. 3. The 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution in excluding the SEBCs, OBCs, SCs, STs from the scope of EWS reservation. Consequently, the transferred cases, transfer petitions, writ petitions, and the petition for special leave appeal forming the part of this batch of matters are dismissed. Our acknowledgements while closing on this reference, sincere thanks and compliments deserve to be placed on record for the learned counsel for the respective parties, their associates and their researchers, and also all the constructive contributors whose erudite and scholarly presentation of respective viewpoints has rendered invaluable assistance to this court in shaping the formulations herein. Thank you.
I'll now invite Honorable Justice Bela Trivedi to place her view.
I have concurred with the opinion of Brother Justice Maheshwari. However, have went down certain my views also. I'll just read them out. As well settled, it must be presumed that the legislature understands and appreciates the needs of its own people. Its laws are directed to the problems made manifest by experience, and its discriminations are based on adequate norms. Therefore, the constitutional amendment could not be struck down as discriminatory if the state of facts are reasonably conceived to justify it. In the instant case, the legislature, being aware of the exclusion of economically weaker section of the citizens from having the benefit of reservations provided to the SCs, STs and SCBCs citizens in Clause 4 and 5 of Article 15 and Clause 4 of Article 16, has come out with the impugned amendment empowering the state.
Account of breach of the ceiling limit of 50% because that ceiling limit itself is not